So we are conducting a webinar on mastering employment agreements. So when we talk about employment agreements, it is one of the most uh, important first and foremost document of the start of your employment or start of an employment of any individual. So what is that about? How should we be drafted? And what it should be all about, what it should contain. That is what we are going to discuss in this. I would rather like to this mother to be the very no discussion. I would like to go on a discussion mode rather than being a lecture mode so that we can understand each other's concern. So to start with, what is that makes an employment agreement, how to draft it, what kind of employment agreements are there, and what is the nature of how they should be drafted. So the employment agreement depends upon the nature of employment, the industry, the position, and the tenure also. So when I speak about tenure, whether that employee is going to be engaged by the company on a full-time mode, as a permanent employee, temporary employee, casual, contractual, or for a specific project for a specific period. So that has to be kept in mind first, and then you enter into an employment agreement. So before I go on with the employment agreement, there is another step which is generally followed nowadays, or which is not mandatory, but it is generally followed, the offer letter. So there is a stage where you first give an offer or an offer letter to the candidate, to the selected candidate, extending the opportunity of joining the employment of the organization, whether it's a company, factory, NGO, or a shop also. So that is a offer letter is given where you express your intent of offering that employment to that specific candidate. In that offer letter also, you have to mention the specific points, especially the tenure, the salary, and what are the benefits in very concise manner. Once that offer is accepted, then you give a extensive or a laid down or basically a more elaborate employment agreement or an appointment letter. So there is a difference in two of the in both the vocabularies or both the terms. When it is an employment agreement, it has to be in the form of an agreement that both the parties are entering into an agreement, and it has to be stamped as per the jurisdiction where it is being entered it. When I say appointment letter, it is kind of a letter issued by the employer. That letter it has to be on a letterhead of the employer and not on the stamp paper. Then the stamping as per the Stamp Act or the stamp is not required. So this is basically an appointment letter which has been given to the employees, which generally was the trend much earlier, like 10-20 years back. Now the trend is entering into an employment agreement. Again, employment agreement and appointment letter. You can also choose to which category of employees you want to issue. If it's a very junior level category like a clerk or a PN or a factory worker, there you can manage it or do it with an employment or an appointment letter where you know that it's not so crucial, or it is not going to give you so much of problem, or not so much of um, importance of that position or importance of that employee is being there. You may choose to enter into an employment agreement when you are hiring a very senior level employee who is very important to your organization, and the clauses are going to be extensive regarding confidentiality, regarding intellectual property, regarding your non-disclosures. If that has to be extensive, where we need to protect the what I say, the protect the nature of job or the information or the information about the companies, not only about the job, then you can enter into an employment agreement. So to decide Whether it has to be an employment agreement or it is an appointment letter, it is for the employer and as well as the person who is working in-house, either it is a HR professional or a legal professional working in-house, they can decide accordingly depending upon the position power, what is going to be used for that position. So employment agreement, as I said, employment agreements, employment contracts or appointment letters. First thing foremost, what is the nature for which they are being engaged? That has to be specified in pursuant to the offer letter, or if offer come appointment letter can also be a single document. In pursuant to that offer letter, you are being engaged in what nature, which position, that has to be specified. Then if that position has been specified, it has to be specified whether you are being engaged as a permanent employee or for a fixed term employment, for a specific project, for a specific period. So if that period, you are knowing that period, then that period has to be mentioned from for a period of 6 months, 1 year, 2 years, but that has to be mentioned to give clarity to the person who is accepting that appointment letter. So that at the end, when his services or employment is coming to an end, he is not coming back and raising a dispute with you. See, I was not knowing, abruptly you have ended my employment. That is not what I had signed for. So the period has to be mentioned. If it's a temporary, it has to be mentioned. So when I started my career, there were a lot of situations when people used to be engaged in place of someone, a daily wager or a replacement or a temporary. So the appointment letter used to mention specifically that so and so has gone on a leave and you are being engaged for that particular month or for that particular period. So for example, maternity leave, people go for maternity leave, people go for medical leave, which is a prolonged period. So in that place, the work cannot stop. So temporary people are engaged, especially it happens in PSUs and government sectors, that for temporary period, that person is employed. So that temporary nature of the employment is specifically mentioned in that appointment letter, as well as the period is mentioned till what time they are being engaged as a temporary employment. What happens, what this helps? This helps in for the employees to know that after a certain period the employment will end and they should be started looking for their own future employment. Secondly, it makes it clear that they don't have any lien or right over the post they are working. They can't come back and say that the employer has malafidely or has fooled us by taking into an employment. There are situations where these temporary employments are extended also, but that there is this discussion is out of the purview of the current webinar. Maybe we can have discussions on a separate webinar related to that. So as I said, there has to be a designation or role clarity and the period clarity that has to be there. The reporting structure has to be mentioned in the appointment letter, that whom to whom he has to report, whether it is a specific position or a specific person. So when I generally draft employment agreements for my client, I generally mention the position. Then what happens if that person is of working in that specific position and I mention his name in the appointment letter and he leaves the employment, then it becomes difficult for me to change the appointment letter again and again by issuing an addendum. So what I prefer is to mention the specific position that you so will be reporting to so and so in the organization, or wait for the directions from the HR. So that is how you mention the reporting structure. What are your key responsibilities? It is really, really important that you mention the job description either as an annexure or in the appointment letter, that these are your key responsibilities, that you are required to do this. Why? Because in case of a dispute, you will be able to understand, or the employee or the employer, both it's beneficial. It will be able to understand what were their actual responsibilities and what they did do and what they did not do. So in case of a misconduct or in case of lapse of duties or lapse of carrying out the duties, you know to pinpoint what he did not carry out. So the job description or mentioning the key responsibilities are really important to mention with as part of the appointment letter or as an annexure. But while mentioning that, a overriding or a general clause should be put into that saying that additional responsibilities can be added by the company or the management as and when required. You can be asked to do certain more work other than which has been enumerated above. So these general clause also protects the right of the employers that they can give additional responsibilities, and also it puts the gives an idea to the employee that okay, fine, it is not that I will not be asked to carry out additional responsibilities. Then the clause of transfer, it is very, very important to mention where is their location, uh, initial location of their duties or job, and that they can be transferred to another location. If you do not protect the right of transfer in the appointment letter or the employment agreement, then transferring that employee in a future date becomes very, very debatable, and it is also amenable to be challenged in the court. So the protecting the right of transfer is very, very important. The fourth thing, which is the remuneration, the X remuneration, what he will be entitled to, what will be the extra payments. So the basic salary and the extra payments mention, and give a breakup in the annexure, because it is really very important to give a breaker in the annexure so that he knows what is the salary he is going to get and what he is going to earn more if he does some specific job. So specific performance incentives or product linked incentives, these are really very important. You know, these are really very important ingredients or important amounts which really encourages the employee to work more. If those clarities are not there in the appointment letter, then it will be very difficult for that employee to understand what he is entitled to and what he is not. So don't mention something which you are not going to give as part of a routine. If those are mentioned, that creates an inherent right in the employees, so that gives them clarity in the mind of the employees what they are going to get and what so don't mention, as I was saying, don't mention the amount which you are not going to give as a matter of practice, because the moment you mention that amount and don't clarify it or don't doesn't then it becomes a matter of practice, or it becomes a condition of service which the employee can go ahead and ask for as a matter of right, that you know what, this was being given to me or this was written, now it has become a condition of service, I want that. So there has to be a specific, when you chart out those amounts or chart out that appointment letter or the annexures regarding to the payment of salary, it has to be done very mindfully. What is to be written and what is not to be written. This the fifth comes the notice period. You have to clearly mention what will be the notice period if the person is going to leave the organization. So every factory or every organization is governed by either the Factories Act or the Shops and Establishment Act. Every Shop and Establishment Act provides for a minimum notice period of 1 month, which can be increased by the employer. And also, every Shop and Establishment Act gives an obligation on the employee to provide a certain period of notice. It may not, there is a, it doesn't have the provision of notice in lieu of in many of the Shops and Establishment Act for the employees, not for the employers. Employers either have to give a notice or payment in lieu thereof, but employees will have will have to serve that notice period. So there is a distinction between regarding the requirement of notice period by both employer and employees. So while drafting the appointment letter, it is best to revisit the Shops and Establishment Act for that particular state, particular location, and see what is the requirement. So when I was talking about notice period, so notice period is very important to mention, whether it is 1 month, 3 months, 2 months, 6 months, and it will also vary as per the position of the person who is being employed. So for a senior level employees, we generally have also from 3 to 6 months. We have 6 months of notice period in certain cases, like CEO, CFO. They have a lot of obligations to discharge. They are there on the board of directors also. So for those kind of a position, we have 6 months of notice period or payment in lieu thereof. So generally, you can buy out the notice period also. So that has to be specifically mentioned. For probationers, if you want to create a distinction that what should be the notice period during the probation period and after confirmation of the probation, then that also has to be mentioned in the appointment letter in detail, so that a person knows if he wants to leave the employment, then he is required to do what and he is not required to do what. So that notice period again becomes very important. Then now, right now, I used the word probation. So whether you want to give an employee, keep that employee on a probation or not is also an criteria which the employer needs to decide. So if you are keeping that employee on probation, mention the months, time period, 6 months, 3 months, whether it is to be extended or not, whether you have a right to terminate that employee during the probation period without payment of notice, that also has to be mentioned. So all the rights which the employer can exercise and wants to exercise basically has to be mentioned in the appointment letter. While that is there, the underlying principle, but the employee's right also should not be overlooked while drafting an appointment letter. Otherwise, it will not stand in the court of law. So when I am writing that, during probation, either party can terminate by giving a week's notice or 1 month's notice, and then I write that only the employer will be able to pay you terminate you by payment of in lieu of notice, and the employee will have to serve the notice period. Sometimes these situations have been challenged in the court on the principles of equity, saying that, you know what, if employer can keep those rights to himself and terminate a person by payment of by payment in lieu of the notice, then why can't the employee do so? How it is fair and based on the principles of equity and justice that the employee has to serve the whole notice period, but the employer can just terminate by giving you the pay? Similar principle can also apply, corollary can also apply to the employee, and the employee can also give you the payment in lieu of the notice and go away if he is getting a better job. So these things are to be kept in mind while drafting the appointment letter. Then what are your expectations? The employer I'm using the word should. The employer should clearly specify the expectations which he has is from the employee. Those KPIs needs to be mentioned either as part of the main document or as an annexure, so that the amendments can be done properly. So this will actually help you in preventing, while doing performance appraisal, then you know that, okay, fine, I have to point out these things while I'm doing the performance appraisals. So then comes the important point, that is termination. You have to be very, very specific when you want to mention that termination clause. Termination on the ground of non-performance during the probation period and after confirmation. So, acha, I forgot. So, when I am keeping a person in probation, that probation can be extended if the performance is not satisfactory, but it can be terminated if the probation is the performance is unsatisfactory. So that clause have to be categorically and clearly mentioned in the appointment letter. Secondly, It is always advisable that you mention when that probation will be confirmed, whether it will be confirmed in writing or it will be an automatic confirmation. So I have a situation right recently when it came to me from one of my client where they wanted to terminate the employee on the basis of unsatisfactory performance. And he was not very much old into the employment. He was like, what, 8, 9 months? So we asked for the appointment letter of the employee that please show us what was the terms and conditions and on what grounds you can terminate. We see that the appointment letter has that you will be on a probation period of 6 months and it is into automatic confirmation. Automatic confirmation is never ever advisable, because if you want to terminate somebody because of the you know the idea of keeping a person on probation is that you can assess their performance during that probation period. So if you have assessed their performance during the probation period and you have found them to be good and confirmed them, then after 6 months of probation, at the 8th month, you're coming and telling that, you know what, I want to terminate because of your performance. So suddenly after confirmation, does his performance has gone down? No, I don't think so. That sounds illogical to me. It may sound illogical to the court also. So that is why always mention what type and when the confirmation and what mode would be the employment would be confirmed, whether it would be through a written confirmation or confirmation on the portal, whether automatic or whether it is after completion of the probation or completion of the extended probation. So always also have a right in the appointment letter to extend that particular probation, that 3 months, another 3 months, maybe another 3 months. So till the time your performance is not satisfactory, I can keep extending the probation so that you have that right of terminating their services because of unsatisfactory performance. Then when drafting an appointment letter, as I said in the beginning, you have to keep in mind for which position you are drafting. So I don't know if people who have joined, they are aware of the concept or the concept of workman and non-workman. That is a blue collar employee and a white collar employee. So on labor laws, these two categories of employees are very much of importance, because more of the labor laws are in favor of the workmen, who are the blue collar employees, and less labor laws protect the non-workmen, the white collar employees. So the non-workmen category employees are basically those who are on a very junior level rung and they are doing works like clerical, technical, manual, and operational. Those category of employees are workmen. And the payment of salary is not important to decide whether that person will be a workman or a non-workman. Non-workman category of employees are those people, those employees who are exercising more of a managerial and supervisor nature of work. So that thing has to come categorically out on the appointment letter. Then with respect to statutory benefits, what are the benefits the employees are entitled to? So I generally prefer, or I generally advise employers not to mention the statutory benefits in detail in the appointment letter, because there is any change in the law, you have to amend the appointment letter, or you have to give up a top up, or you have to give an addendum. What I prefer generally while I draft an appointment letter and I ask my employers, I say statutory benefits as applicable as per law. So I don't, then if there is amendment in the appointment letter, it will not have to be revisited and any further documentation is not required to be given to the employees. So the statutory benefits such as gratuity, PF, ESI, maternity benefit, bonus as per the Payment of Bonus Act. It has to be as per the applicable law. Don't mention that all those provisions of maternity benefit need not to be mentioned in that appointment letter. Once you write it is as per the as per the applicable law, then the employees are entitled to either look up or the HR is fully knowledgeable to give extend those benefits as per the applicable law. So bonus is generally given to employees earning less than 21,000. PF is given to employees earning less than 15,000, and it becomes applicable only when the organization has 20 plus employees. ESI is given to employees earning less than 21,000. So if you are going to mention, then it will be a tedious job for the HR to rewrite all those appointment letters again and again the moment they are extending it to the giving it to the employees. So but if there is a standard language in the appointment letter that statutory benefits will be extended to you as per the applicable law, then you don't have to get into the details each and every time you are issuing this appointment letter, except for specific details like name, place, designation, location, and the salary. These things are, so you can have a basic template ready with you or the HR. So while the professionals, lawyers have to keep in mind when they are vetting an appointment letter, they have to see whether the appointment letter is in accordance with the applicable Shops Act or the Factories Act. The HR managers who are attending this, they have to keep in mind that they have a standardized document only to be worked upon it, and that same standardized documents are not to be cyclostyled and given to the employees. So optional benefits, like if you are extending some optional benefits like medical, Mediclaim, ESOPs, whether it is an allowance, whether it's a tuition allowance, travel allowance, conveyance allowance, how they are entitled to, what is the criteria for their entitlement, and how it will be reimbursed. Generally, medical allowance, Mediclaim and conveyance allowance are given to employees so that they can save on the tax. But let me tell you that it may impact the EPF at the long run, because any amount which is given to employees as a as a wholesome amount across the board, that may impact the EPF takeaway also on the contribution of provident fund. So the reimbursement should be made on the actuals. At least on the papers, it has to be mentioned that reimbursement will be on the actuals, so that that will not hamper the provident fund, or it will not affect the provident fund contribution. That way both the employer and the employees are saved from the extra financial burden. The most important part when we come to the appointment letter is in today's days, is the um, confidentiality aspect. When I say in today's days, it is because now we are more exposed. Now we have more what do you say, the technology, the breach is happening much more. Earlier, these aspects were not that important. What is important earlier, because I've been in the profession for last 20 years, so I know that 2 decades what has all changed. Now with the advent of the technology and the you know getting into so much of exposure, there is an danger, or there is a threat to the confidential information of the companies, especially those who deal with intellectual property matters, those who deal with data sciences, the financial institutions. They are always under a threat that my employee is going out and he will go out with certain number of information, confidential information, he may share it with the competitor, and that is not what I want. So I want to protect those rights of mine with the employees. So a must have clause in the appointment letter is the confidentiality. It should be exhaustive, and you should specifically mention apart from that generic clause of confidentiality, that every information being shared with you during your employment is confidential. You should specifically mention all the confidential information which pertains to your industry, whether it is a client list, customer list, employees list, the datas, the inventions, those discoveries, everything, all small details, the sales target, the projected sales, all those should be mentioned in the confidentiality, that these are our confidential information, and any violation to the confidential information will land up you in a dispute. Those things has to be mentioned. What will not be included as confidential information is that public info. That something is there already there in the public. Prior knowledge. He has come from a certain experience, certain background, and he has prior knowledge about the company or the process or the know-how, the technology he already knows. Unless and until you have, because of that employment that is being topped up, that prior knowledge will also be carved out from that confidential clause. And legal disclosure, where he is under legal obligation to disclose it, there you cannot enforce that confidentiality agreement. Similarly, when it comes to intellectual property rights, so any, you have to maintain that key, those which are developed by you during the course of the employment, those will be clearly confidential and will be the property of the company and you cannot take away. So researchers, scientists, developers, software developers, they all develop something, they all do something new for the company. So that product is not possible if they would not have been in the employment of the company. So it is not their property, but it is the property of the company. So this is exactly what is to be written, or this is exactly how detailed those clauses have to be. The non-disclosure, confidentiality, and the intellectual property rights have to be protected under the appointment letters. Again, as I say, it will depend upon the position. Maybe a factory worker or mason may not be having this detailed confidentiality clauses, but a VP, CEO, or researcher, software developer will definitely be required. So if there is a situation where the appointment letter doesn't have all these clauses, then we do advise our clients also to have an additional agreement, a confidentiality and non-disclosure agreement after they have joined the employment and they sign those extra agreements, those top-up agreements, which would be read as part and parcel of the appointment letter also. But another thing which has become very important nowadays is the dual employment, the moonlighting effect. Not all the Shops and Establishment Act or the Factories Act have this exclusivity clause. While they say that you will be working for 8 hours or 9 hours for a particular employee and you should not be working for more than 12 hours in a day or 10 hours in a day, it doesn't specifically mention that it has to be, you have to work with only one employer. The whole idea of overtime and the whole idea of specifying the number of hours was that they have to work for only one employer, if I interpreted that manner. But nowadays, with work from home, online working available, people are moonlighting, people are doing dual employment. So your appointment letter nowadays, it has become very important to have a clause of exclusivity, that one job at a time, that this, you are exclusively my employee and you cannot work with any other on the similar nature of job. You cannot work with any other without my prior consent. Maybe if you come and ask me for my consent, maybe I'll give you a consent considering anything like, financial constraints, or maybe that job is not of the similar nature of the company and you are doing it as a part-time or a free will or just a freelancer, or being just an help, extending your helping hand during the weekends. So that has to be particularly captured in the appointment letter nowadays. So that exclusivity has to be there in the appointment letter. Now comes the question, what about those restrictive covenants? A lot of clients come to us and ask, what about non-compete? What about non-solicitation? Are there, should we be having them? Should we not be having them? Despite of various judgments saying that non-compete clause is non-enforceable after the conclusion of the employment, still people want to have it for a deterrent effect. Although it is, the non-compete clause is not enforceable. Recently, Delhi High Court judgment has also come that non-compete clause after the termination of employment is unenforceable, non-enforceable. Still, people want to have it in their appointment letter to give a deterrent effect. Nowadays, employees are getting aware that this is not going to be enforced. So that is, the deterrent effect is also losing its effect. But still, we do have it for certain reasons. First, letter and effect. Second, if that employee has gone away with your confidential information to a competitor, then how do you enforce it? So if you couple it up with your non-confidentiality clause, maybe you can get it enforced. There are certain judgments when the person has gone with the confidential information, joined a competitor just with the malified intention to harm the business of the company. So that is why there the court said that yes, non-compete is enforceable because it is stealing of the confidential information. So it was more of a confidential information judgment rather than on a sole clause of non-compete. So that is why we say that okay, fine, have it, but with a clear information or a clear message to the clients that non-compete clause are not enforceable as a standalone clauses. Non-solicitation clauses, even after the employment, again, if that person who has left the employment is trying to solicit your clients, your customers, your employees, telling that you come and join me, I have all the information of the company and I'll be doing much more, then it is definitely enforceable. Then training bonds. Clients come up to us and ask that, you know what, we want to enter into or put a clause in the appointment letter regarding training bond. That if you don't serve us for a particular period after we have confirmed your services, then you are supposed to give me this much of amount. This used to happen a lot with the nurses in the hospital sector. And of course, in the PSUs also have seen. My brother, when he joined Delhi Metro, DMRC, he also had a bond that if he leaves the employment before 3 years of service, then he has to give a certain amount of money. There, again, it's a circumstance-based clause. If the employer is providing a certain specialized training or giving any sort of training education which the employee did not have prior to joining the employment, then there the bond is enforceable. So it has to be a reasonable time bond, reasonable amount bond. There has to be an actual investment in the training, and it should not be punitive in nature. That you are not putting that bond as part of a punishment, that just because you have given them the employment and they are leaving before a certain period, so you are punishing them or you are trying to settle your ego with them. So that intention doesn't have to be there. It will, what it will help you in getting your reimbursed the cost which you have put into the there was a recent judgment, right, where it has been held that even if situations where nowadays a lot of hiring is done through our employment this placement agencies or placement consultants, through consultants, so they take a certain amount of money. So even if that is a, I have gone through a specific criteria of advertising, hiring a placement consultant or an employee consultant, and I have paid a lot of money, the court said that you can, in these circumstances, you can also take that amount from the employee. So training bonds, the cost, if it is actual, if it is, can be justified through documents, then it can be enforced. Then leave, working hours, all the HR terms, whether to keep it in the appointment letter and in the policies is one debatable question. While my view is that it will always, like again, leave, working hours are statutory benefits or statutory rights. So it has to be mentioned that leave as per applicable law, working hours as per applicable law, and you can have a detailed policy on the leaves and HR. But the reason behind it, why I advise that way, is that if there is a change in the law, then you have to change and amend the appointment letter, which becomes very difficult because it has to be again signed by the employees. Sometimes employees don't consent to the change in the appointment letter and change in the terms and conditions of the service, for the very fact that if they have been entitled to a certain better conditions, and now you are trying to change it into a lesser condition, or even if it was a lesser condition, they were getting much more benefit from that lesser conditions. If and you are trying to top it up, and the benefit is going to be reduced. So that is why I always advise the clients to have the detail of the leaves, the procedure they have to apply for the leaves, the working hours, the overtime, whether they are entitled to, whether they are not, and what is the way they should seek an overtime. And if they have worked overtime as per the permission of their seniors, or they have just sat through the day, did nothing, and they sat in the night to complete that work, all should be exhaustively written in the policies, which is core policy or the employment manual or the work policy, leave policy. So by whatever name, because that way you don't have to make it an exhaustive or a bulky employment agreement or a appointment letter. Appointment letter generally should be, a simple appointment document which is understood by the employee, but at the same time it is also conveying all the important points to the employee. The leave entitlement, again, if you can encash those leave, you cannot encash those leaves, all those things have to be generally mentioned in the leave policy or the HR policies. Then how, if there is a dispute, how do you resolve that? That's the last clause. What is the jurisdiction? Which law would be applicable? Which court will have the jurisdiction? All those also have to be mentioned in the appointment letter. Because sometimes what happened, my registered office is in Delhi, but my employee is working in Mumbai, then which court will have that jurisdiction? So that it is very important to mention that. Again, again, in a recent case, before the Delhi High Court or the Bombay High Court, it has been mentioned that if the jurisdiction or the dispute resolution clauses have been agreed by the employees, and the employee has signed it and the employer has agreed to it and signed it, then it doesn't matter. It can be a third state also. So my registered office is in Delhi, employee working in Mumbai, but I can have a court jurisdiction of Chandigarh or a Gurgaon. So that can also be done. Then you have to decide whether it has to be a court, dispute resolution has to go to a court, or through a arbitration. Generally, when I draft the appointment letters and I advise my clients, for the lower rung, for the non-workman category, I don't advise arbitration, because that's a financially constraining provision. And workmen category or the lower rung employees are not in a position to go for arbitration. That is also unfair. They can directly go to the court through Industrial Disputes Act or to civil suits, and the courts have come to a conclusion that you can't have arbitration for these kind of employees where they cannot afford. They are also not knowing those legal complications when they are signing those appointment letters. They are not knowing the implications of these clauses also. So arbitration. But for senior employees, CFO, CEO, vice president, general manager, or assistant general manager, director level, we advise for a arbitration. That helps the company to get what they want from the employee, for reason if they have confidential information in their position, if they have certain documents, important documents in their possession, or even the employee gets the employee gets the desired terms and they part amicably. So the parting the ways amicably is also another point which has to be taken care of while drafting that dispute resolutions. Then comes the whether the appointment letter should have a retirement age. Yes, it should have a retirement age. I have come to a situation where there was no retirement age and the employee is still working. He is 70 years and he's still working, saying that nowhere it is written that I should be retiring, because your appointment letter doesn't mention so. Neither it says that if you are medically unfit, then you will be going out. So the retirement, when we draft the termination clause has to be as per your notice period, if in case of a misconduct and in case you reach a certain age. That is the termination clause. So the termination clause also has to be very exhaustive. Then comes the stamping. Lot of clients come to us and ask whether I should get my employment agreement stamped. So when it is form of an agreement, I do advise them to stamp, because then it helps them to enforce certain clauses like not indemnity clauses, which I generally don't advise people to put it in the appointment letter, but in an employment agreement, indemnity clauses are invariably there, especially for senior level employees. To get that indemnity enforced, we do advise to, if it is in a form of an agreement, so and so party, employment agreement is being entered into between so and so parties, then I do advise them to get it stamped. Appointment letters are not required to be stamped. Under the employment laws, there is no requirement of stamping. Unstamped employment contracts are valid and enforceable in the court of law. So these are the the major points which has to be covered in the appointment letters while drafting that appointment letters. The location, the transfer clause, resignation clause, termination clause, notice period, probation, confirmation, and the statutory benefits, and of course the remuneration. So now, if we are okay and people have questions, we can get into that.
Ma'am, there's a question. What not to miss in an employment agreement according to you? Ma'am, already extensively you have discussed. So,
So not to miss is, as I said, you should not be missing the position, the job description, the transfer clause, the probation, confirmation, and the remuneration clause, and of course the confidentiality clauses. These are the clauses which you should not be missing, and the duration, matlab the specific position, permanent, temporary, fixed term employment. Those are the things you should not be missing.
can an employment agreement have an arbitration clause?
Yes, it can. It can have, definitely.
Okay, ma'am.
Yesha is asking a question.
Ma'am, if we already have a confidentiality clause in our employment contract, do we need to, make the employees sign a separate NDA?
Yeah, they can still sign a separate NDA, because maybe your confidentiality clause in the appointment letter may not be that exhaustive, or you want to top it up with something else. They can still sign an NDA.
Okay. But usually, if it's covering everything, then the NDA is not required.
No, then it is not required, but depends upon what is the situation and why you need to get it signed.
Okay.
If there is a
Thank
specific instance which has triggered this requirement, maybe it is better to be safe than to be sorry.
Okay.
Ma'am, there's a question. What is an implied employment agreement?
An implied employment agreement, which is oral, that is an implied employment agreement, because under the Indian Contract Act, oral contracts are also valid and have been recognized. So if I have not given an appointment letter to my employee, but I have kept that person in my job and I'm paying the salary, the PF, then that is an implied employment contract.
Okay.
Mohini has the question.
If the agreement is not registered or affidavit, then it is valid. We can challenge that agreement in the Industrial Dispute Act.
See, industrial dispute challenging your termination. When you go through an industrial dispute act, it is basically either you are challenging your termination or you are seeking some kind of your benefits from the court.
Yeah, if salary is not received for last 3 months, but you
Huh.
told now that agreement should be registered or affidavit
No,
with the
no, no,
employer.
no. If you have to go through industrial dispute act, then you don't need to have a registered agreement. What I said, that if it is in the form of an agreement,
Yeah, that
generally,
offer letter they have given,
ha.
and that all everything is there, but employer has not given salary to the employees
So
for last 3 4 months.
you can directly approach the court or the labor authorities that.
Yeah, I approached the court, but secondly, their register office is not accepting any letter. So I took that notice on a paper notice. That is
I
also
did-
valid, na?
yeah, it is valid.
Okay, fine. Thank you, madam.
Yeah, it
Thank you.
doesn't have
Yeah.
to approach the labor court. Your employment agreements or your employment contract are not required to be registered on a
Yeah, not
stamp.
register means that agreement is not registered by employer employee.
No, it is
Okay.
not required. Unstamped employment contracts are validly enforceable in the court.
They have given salary for this more than 2 years, and then there was a 3,000 employees, and they started cutting down. And before they will give the insolvency, I have to file the. I had filed in a Bandra court,
Okay.
but that agreement is not registered. That's why I asked this question.
No,
Okay.
need not be, need not be. Registration, the payment of stamp duty. When I say registration, it means it has the appropriate stamp duty has to be paid. If you go to a labor court, that is not required. But if you go to a civil court and an objection is taken that this document is not properly stamped, then the deficiency or the fine can be paid in the court and it becomes a valid document. Your
Okay.
employment cannot be null and void because you have not paid the stamp duty.
Okay. And what is the other remedy where I have to go approach this instead of ID code, Industrial Dispute Act and civil court, other remedies?
I think you have approached the right court. I don't
Yeah.
think you should be going anywhere else.
Yes. Okay. Thank you, madam. Thank you. Nice to speak to you. Okay.
Thank you.
Great day.
Thank you, Mohini ma'am. Ma'am, there's one question in the chat box. In the retirement age scenario that you just mentioned, can't the employer's policy be amended?
Retirement age, if you have mentioned it in your policy, whether it is 60 years, 58 years, or as per applicable law, then if there is a change in the applicable law, you can amend your policies. Or if you want to unilaterally change that retirement age without any law being changed, then you would require the consent of the employees to accept that
Okay, ma'am.
or enforce that.
Ma'am, there's one question. What is the difference between contract for service and contract of service in the practical world?
So there is a lot of difference there is a contract of service and contract for service. Or we all employees are contract for service. It is not contract of service. So the difference is that of a key difference in both the contract of service and contract for service is the difference of control and supervision. So contract for service is generally for person like me. I am under the contract for service because I'm a lawyer. I'm not an employee. I'm a retainer for a certain organization. That is contract for service. Whereas employer-employee relationship is more of a contract of service because there is a certain degree of control and supervision by the employer. So that is the difference between contract of service and contract for service. So when you hire a third party worker or a contractor to provide you services or to give you manpower, that is contract for service. Whereas when you directly hire that person on your roles, that is contract of service. So practically, this is the fundamental principle on which all the employment contracts are governed, whether it is appointment letter or a third party service contractor. So this is completely recognized in a practical world also, in a legal world also.
Okay, ma'am. Ma'am, the next question. What is your opinion on renewal of employment agreements? Should the agreements be subject to renewal?
See, this is a different question altogether. So, if you are issuing an appointment letter to a permanent employee, then there is no question of renewal comes into play. Renewal comes into play in case of a temporary employee or a fixed term employee. So fixed term employee, when I say that you have hired somebody for a specific period of 3 months, 6 months, 8 months, 1 year, 2 years. So after completion of that 2 year, if you want to renew that, then you might have a clause in the earlier existing one, or you can just enter into a fresh contract or a fresh agreement. But for permanent employees who have joined the employment as a permanent employees, the contract, there is no question of renewing it over one period, 1 year, 2 year, 3 years. It is a one lifetime document till the time the person either leaves, terminates, or gets retired for that employment. Coming back to the renewal question, if you have hired a person on a fixed term contract and you are renewing it, on and on, then that raises a question in the mind of the employee as well as in the mind of the court, if he goes to the court, that this is a position where you need a permanent employee. It's a permanent nature of job, but you are deliberately not keeping a person on a permanent employee to avoid the statutory benefits. So that is why you are renewing it. So it will depend upon facts and circumstances why you are renewing it and why you have not kept a person on a full-time employment. So the statutory benefits comes into play, then the gratuity may become applicable, the PF, ESI, the leaves, everything. It's a, play of characters there.
Ma'am, the next question, having an essential skill set for a particular role, should it be clearly mentioned in the employment agreement?
I think it is better to mention that in the employment agreement that you have been hired because you have this particular skill set. Or when you are trying to hire somebody, then it should be part of your offer letter or your advertisement that this position is for this specific skill set. Then you are hiring person and you are confirming that because you have this specific skill set, I am hiring you. So it is good to have that clarity as part of your appointment letter, whether in the appointment letter or as part of your job description. So when I talk about job description, that is what the skill set means. You have hired a person for a specific, on the basis of a specific skill set. That is why there has to be a job description enumerating and listing out that what he is required to do 1, 2, 3, 4, 5, 6, 7, 8.
Okay, ma'am.
Hopefully it is clear, or otherwise he can write again on the chat.
Yes, ma'am.
Again, Mohini ma'am wants to ask
Oh,
something.
sorry, once again I came back.
No issues.
See, nowadays there is a frequently changing job scenario.
Yeah.
Then in that case, how will write down this is a permanent employees or temporary employees for that project employees? That clause should be there
So there
because
is,
for betterment, this generation are changing jobs.
yeah. So if they are changing job, it is their requirement. Your requirement is that whether your position is permanent in the organization. Like if it's a accounts manager, then it is a permanent position.
Hmm.
But if you are hiring a person for just, okay, like let me give you an example. Airlines industry, there is a catering industry in the airlines who caters
Yeah,
to all the planes, the food
yeah,
and all. Okay, the catering
yes,
industry, the airlines. So the catering industry in the airlines is a fluctuating job.
yes.
See, few airlines added, few deducted. So their meals, the orders, the meals keeps going up and down. So
Yeah.
then they cannot afford to have a large workforce. So what they do, they keep the employees on a fixed term contract, saying that it's a very temporary or it's depend upon the business which I get. If my business goes down, then that contract may end sooner also. But they
Means-
keep all those employees on a fixed term contract. Whereas if I go to a hotel is a housekeeping industry, is very essential and core to the establishment, core to the business of that organization. I can't have all those people on my fixed term contract or on a temporary role. Those are my permanent roles. An HR manager, a florist, a receptionist. So it will depend upon where you are having uh, our construction company. Construction companies keep doing projects. L&D. I am having this project here. I'm having that project here. So for that completion of the project, there will be certain employees who will be already working in the office, but a project comes to me. So I will have a specific term for that project that the government has given me. In 2 years, this has to be completed. So if I require, I will hire another engineer, civil engineer, electrical, mechanical engineer for that specific 2 years, where I say that you are being hired per se this project only, then my term has been mentioned. So it doesn't have to do anything about the permanency, it doesn't have to do anything about the changing of the jobs, but permanency has to do about the position, what is essential for your organization and what is a short-term requirement.
But that is, we know the certain period, how long this job will run. But there is no certain period, and the employees is have to give the permanent or temporary.
But there is a certain requirement. A director is it not a temporary requirement. It's a post which will definitely be required. If there is an employee, a manager, so if I have to run a business, then I have to have a certain workforce which I require permanently to manage a business.
But that is not written in the agreement. This is a permanent post, or leaving the job is our
If it is
consent.
not written in the agreement that it is a temporary post, then it will definitely be interpreted as a permanent post.
Okay, okay, fine, fine, good, got it. Thank you, ma'am. Okay.
Thank you, Mohini ma'am.
Swati had raised her hand. Yeah.
Okay, yeah.
Good afternoon, ma'am. I just have a query that
Yeah.
if there is no notice period is mentioned in the appointment letter, can
Hmm.
an employee resign with the immediate effect?
If there is no notice period in the appointment letter, then the employee can resign with immediate effect. But certainly, the unsaid rule is that the applicable law will come into effect. That under the Shops Act, if it is applicable to that organization, under the Shops Act, there is a minimum requirement of 1 month. So you should. But if it is not written, then the employee is at liberty to just leave the job and go.
Okay, ma'am. Actually, in the applicable law, it was written that the employer has to mention 1 month's notice period in the
Appointment letter.
appointment letter. Otherwise, there is no requirement of it. So, if therefore, I'm asking.
So I'll tell you, Maharashtra Shops Act doesn't have the provision of notice period in the Shops Act. So
Okay.
if it is not written in the appointment letter of a Maharashtra company, then the employee is at free will. He can just go away one day without giving you any note.
And
If you don't write
okay,
in
ma'am.
the appointment letter.
Okay, ma'am. Thank you so much.
Okay. So Payal just raised hand.
Hello, ma'am. Good afternoon.
Good afternoon, Payal.
Ma'am, just clarify me the permanent jobs and the temporary jobs. What is the difference between the both agreements done between the employer and the employees, and what is the assurity between both the jobs? Permanent, obviously, it is for a long term and a firm job, but still, what are the company-wise differences?
See, the difference between permanent and temporary job is of the requirement. If you require a certain service for a temporary period, that is a temporary job. That I require a sweeper only for 3 months. That is a temporary job. That means there is no post as such or position as such in my company for a sweeper, but it was a requirement for a short period. So that is a temporary job. Or if I'm hiring somebody in place of, so I used to do a lot of cases for Air India. So Air India, what used to happen is that stenographer used to go for a 3 months medical leave. So they used to have a stenographer for that 3 months. So that was a temporary job for that particular employee. It was a permanent position in Air India, but it was a temporary job for that employee who had joined in place of some other person. So that is the difference. If I have been able to clarify that, is it
Yeah,
clear?
ma'am. Yeah, and difference between both agreement. When we do the agreement with
Then
any
the difference between both the agreements is that you have to mention the time period very clearly. His appointment is being done in place of somebody else, and it is a temporary job. It is not a permanent job. It is not a permanent post, or it will coming to an end at the expiry of these 3 months. And the salary may be different from the permanent person and the temporary and the leaves, whether he would be entitled to any leaves or not, the statutory benefits things. So this is the distinction when it comes to the agreements.
Yeah, for example, companies give various allowances, gifts to the permanent
Yeah,
employee.
then he will not be extending those to the temporary ones.
Acha, temporary employee will not get all these
No,
allowances and
no,
gifts.
no, no. So
This
it
was
actually depends on the discretion of the employer. So generally, the employer always writes that you are not entitled to the perks and benefits which the permanent employee is entitled to. So there is a standard clause in the temporary agreement.
because, as we know, India is a nation of festivals. Many a times it happens a permanent employee can take a leave at the time of, we can say, Diwali. So Diwali is a big festival where a big number of amount of allowances and gifts are given to all employees. So I'm concerned about this at the time of this duration when a temporary employee is employed. So will he be given or not?
It will be the discretion because this is not a statutory thing. So it will be the discretion of the employer. If they want to extend it, they can extend it. If they don't want to, then they will not be required to.
Okay, these allowances are not binding on the temporary employees.
Yeah, these allowances. So it is a discretionary extension of benevolence given by the employer. If the employer wants to give it, then give it. But statutory, yes, they are entitled to statutory benefits. Like even for a temporary employee, PF should be deducted. Even for a temporary employee, they are entitled to leave that has to be calculated pro rata the number of days they have worked for. So those statutory things they are entitled to, but for all these discretionary things like gifts, customary benefits, that they are not entitled.
Okay, thank you, ma'am.
Okay.
Hello. I want to ask you one question that there are any special clause for position like virtual assistant who work for foreign countries or specifically a proprietor.
Yeah.
Why I ask you such question, because they provide the salary clause, and in that salary clause, actually, if suppose the person is working for Singapore, they got the salary in HGD, right? They converted into INR. That difference is a bank charge difference, right? So, is there is any special clause for such kind of thing?
No, yeah, as I said, the remuneration part has to be mentioned properly. What is to be like we mentioned that, all the tax or the deductions will be done as per applicable law or as per applicability, or you will be required to pay those taxes at your end. Employer will not be hold responsible for any lapses. So if you are having somebody from outside and those bank charges, it is better to write those down in the appointment letter or in the annexure to give the clarity that what they will be required to do and what you will be required to do. It's more from the taxation point rather than from the employment point. But it is better to have a clear understanding. So if something is being documented, it is always advisable to document it in clarity and not to withhold some information which is going to create dispute at the later stage.
Okay, ma'am. Thank you so much.
Okay, Krupa. So, ma'am, we are done with the queries. Can we conclude?
Yeah, sure.
Thank you so much, ma'am, for such an illuminating webinar. It was a great learning experience. Thanks for your time.
Thank you. It's my privilege. Hopefully, I've been able to give some clarity to the participants.
Yes, ma'am, we got a lot of clarity on the topic. So, thank you,
Thank
ma'am.
Thank you. Take
Bye,
care.
ma'am.
Bye, participants.